Hello, viewers and students. I welcome you in my YouTube channel at lecture series on labor laws first. Students, today we are going to discuss the concept of retrenchment under Industrial Dispute Act 1947. Section specifically 25F and section 25F(Z). Friends, firstly, we must understand what is the concept of a retrenchment. See, the retrenchment is a terminology that is generally used in industries. See, the retrenchment is nothing but the discharge of surplus labor in industry. Surplus labor is not a new concept for industry nowadays. There are many instances like the recession, etc., where the industries retrench their labor due to, as it results as surplus labor. See, when employer of any industry finds that he has excess workers than actually required, then such workers are called as surplus workers. Then the employer has a right to terminate the service of such excess workers, and this is called as a retrenchment. So when the workers are more than actual requirement, the extra workers can be called as surplus workers and their services can be terminated, and this termination comes under the retrenchment. This is not the suspension, this is not the dismissal, but this is the retrenchment. So their services are terminated because they are not now required, because as you know, there is a rule of demand and supply, so that number of workers should be equal to what the number of positions available in that industry. If the position of workers are less than the available workers, then the extra workers can be terminated. Now we must see what is the definition of retrenchment. Section 200 of Industrial Dispute Act defines the term retrenchment. So the retrenchment is nothing but the termination of services of employee by employer for any reason other than punishment. See, the definition doesn't provide what is the reason why the services are terminated. The basic thing you must remind is that such worker is resulted as an extra than a requirement. So there is no specific reason is necessary, but that employer must justify that how that person is extra than his need. So this is the definition, which provides that the termination of services of employee by employer other than punishment. Because when any services are terminated for as a result of punishment, then that is not called as a retrenchment. That can be the case of dismissal. That can be the case of dismissal. So this is called as a retrenchment, but it does not include the termination of services due to following reason. Retrenchment does not include the termination of services for following reason. Number one, when it is a voluntary retirement by workman. Then secondly, when the workman is retired at the age of superannuation. Superannuation age means the maximum age limit where the worker has to compulsorily retire from the work. Then third reason is termination of service due to long ill health. There are certain diseases where there is very rare possibility that workman may get recovered from that disease and may rejoin the work. So in such circumstances, the employer is allowed to terminate his services for long ill health. So such non-employment cases are not included into the definition of retrenchment. So that in simple language, retrenchment is nothing but the termination of service of extra or surplus labor. See, with the help of this definition, we can find certain essentials of this concept. The first essential of retrenchment is it is termination of service of workman. Termination of service means it is end of employment. Then the service of workmen are terminated by employer. Yes, there must be the employer and employee relation at the time of termination. Then third essential is that services are terminated for whatever the reason, but not for the result of disciplinary action, not for the result of punishment. The termination should not be in the form of punishment to that workman. Then fourth essential is that retrenchment must be justified. It must be for a valid reason. It is responsibility of employer to justify the reason for the retrenchment. Now we must see what is the precondition for valid retrenchment. The section 25F, it provides certain safeguards for retrenched workmen. If any employer wants to retrench the services of any workman, he must follow what the preconditions that are provided under section 25F. That condition must be existent before retrenchment of service of any workman, and these conditions are under. The first is the employer must follow certain conditions. These conditions are provided by section 25F. According to this section, an employer cannot retrench any workman who has completed continuous service for 1 year without following the following conditions. See, he cannot retrench any workman without number one, prior permission of government for retrenchment. So when any workman is going to be retrenched, his employer must obtain prior permission from government for his retrenchment. Secondly, he must give written notice to workman, and this notice must be given 1 month prior to his retrenchment with the reasons for retrenchment. So this is second reason. Third reason is he must pay 1 month wages in case of 1 month prior notice. See, the second condition and third condition are alternatives to each other. Firstly, the priority that government must obtain permission from government to retrench the workman. When the government gives the permission, then it is responsibility of employer to give 1 month prior notice to workman who is going to be retrenched. But where employer wants to terminate service immediately without giving 1 month prior notice, then it is responsibility of employer to give the 1 month's extra wages to that workman at the time of retrenchment. And so this 1 month's extra payment should be given in the lieu of 1 month prior notice, because 1 month period is necessary for the employer, for the employee to find new job, or at least that will help to him, or that will give him an idea that his services are going to be terminated after that period. So this is the third condition. 1 month extra wages should be given, 1 month payment should be given in the lieu of 1 month prior notice. And the fourth condition is that he must pay compensation at the rate of 15 days average wages for every completed year of service. This shall be paid, this shall be calculated, and this shall be paid as per section 25N of Industrial Dispute Act. So this section 25F is very important, and the employer must follow this condition before terminating services of any workman. Now we must say what is the procedure that must be followed by the employer while terminating the services of workmen in his industry. First is section 25G provides the procedure for the retrenchment of workmen, and according to that, it is duty of employer to prepare a list of workmen who are found surplus. So before terminating the services, he must prepare a list who are found as extra workers or who are found as a surplus worker. Then he must obtain prior permission as provided in earlier section. Then he must apply a rule, he must apply a principle for the termination of services, and this principle or this rule is last come first go principle. Last come first go principle. So according to this principle, the employer shall ordinarily retrench the service of that workman who is the last person employed by him. So this will do minimum injustice with the workman. This will do minimum injustice with workman who has given more time to that industry. So the person who is a junior in that list shall be firstly terminated, and according to that seniority, the person shall be terminated. So the person who have worked for more time should be protected against retrenchment also. Then we must see what is the provision relating to compensation. See, when any employer obtain the permission for the retrenchment, then he shall pay compensation to every workman to whom he is going to retrenched, and that compensation shall be paid as per the provision of section 25N. And according to this provision, it is the responsibility of employer to pay 15 days average wages for every year of completed services, and this is the compensation. Say for example, if any worker has completed 10 years of service in that industry and his monthly salary is rupees 3000, in such circumstances that person's compensation shall be 1500 into 10 year. So what the resulting amount will be the compensation of that person. Then next provision is for the re-employment of a retrenched workman. See, this retrenchment is nothing but the termination of service because such workers found extra. So when there is any opportunity of employment in that industry, the retrenched workman has first right of re-employment in that industry. So whenever there is opportunity of employment of new workers, the retrenched workman must be given preference for employment, because he was terminated because at that time there was no position available for him, but now the position is created. Therefore on that position he must be employed firstly. If that person is not available, only then other person will be considered. Now we must see what are the penalties. Penalty for a retrenchment: the employer who contravenes provisions relating to retrenchment shall be punishable with imprisonment up to 1 month, or fine up to rupees 1000, or with both. So friends, this is how we have discussed how the retrenchment is the termination of service of surplus worker and how he shall be terminated, and lastly he shall be terminated by payment of compensation. So friends, if you like this video, please share it with your friends and do not forget to subscribe my YouTube channel. Thank you friends.